Hi and welcome back. Today I'm joined by Reese Sobol. He's a lawyer practicing in the field of medical malpractice with Gara Germano, where he focuses on representing plaintiffs in complex and often deeply personal claims. He brings a very interesting perspective to this conversation because his path to law was shaped early. He grew up in a household where the law was not simply a profession but a part of daily life. His father served both as a personal injury lawyer and later on as a judge. So this grounding is reflected in his approach today. It's thoughtful, it's disciplined, and firmly rooted in the realities of litigation. So before entering practice, Reese serves as a judicial law clerk in the United States District Court. And this is a particular experience that gave him a clear view from the bench, how decisions are made, how arguments are weighed, and where cases succeed or fail. So in this episode, we're going to explore his journey into plaintiff practice, the influence of mentorship and hard work, and how younger lawyers can begin to build credibility in a demanding field. We're going to touch on a subject that is increasingly difficult to ignore, the subject of artificial intelligence in legal practice, and what that might mean for the future of medical negligence litigation. So this is a conversation about preparation, perspective, and the realities behind the scenes that reach the courtroom. So, Reese, welcome to Beyond the Gavel.
Thank you so much, Professor Peyton. I'm happy to be here.
It's great to have you. And you have a different background. I mean, your dad was very much in law and you were brought up with that, and then he became a judge. So how did that influence you? You know, some people are turned on because of what their parents did, and some people are turned off. So what turned you on to the law as a profession?
I think there's a number of things that really appealed to me about it. Um, one thing that was really helpful, I guess, as far as my dad's influence is he never pushed me into it. He encouraged it. He told me he thought that I would be well suited to go into the profession, but he never once, made it put any pressure on me or made it seem like that was his expectation. In addition to that, I grew up as an athlete and I saw the sort of competitive aspect of the practice of law that is intrinsic in litigation. It's an adversarial setting. Unlike, a lot of other different kinds of professions, it's one where you go in to work every day and there's, a winner and a loser on the side of every dispute. And so that part of it and continuing to compete and being in a live courtroom setting is something that I always thought would be exciting. And I would enjoy the pace of it and getting to continue to, I guess, feed that competitive spirit that drove me in athletics for most of my life.
So what athletics did you do?
Well, it's primarily football, American football. I also ran track in high school as well. And when I was younger, I played basketball, but I was never much of a basketball player, to be honest with you. Football was my main sport.
Isn't that interesting? One is a team event and one is an individual event. Which appealed to you most?
Well, I think the team event definitely appealed to me most. I loved working together as a team, and I love, football in my mind is the ultimate team sport. It's the one sport where, you have 11 guys on a field at once, and 10 of the 11 can do everything perfect. And if the 11th man makes a big mistake, then, it can really kill your team. So it really is, that's why I say I think it's the ultimate team game because everybody has to do their job and you're relying on the person next to you. And, you're part of what makes you want to do well is not just your individual success, but it's also to serve your teammates well and not to let everybody else down.
Isn't that interesting? Because when you talk about that, I mean, you have some very well-known players, soccer, American football, and individually they're brilliant. You put them together, and we find it in soccer when you put them into or rugby, put them into a national team, and they want to be it, and they don't work with the rest of the team, and the country team goes down, even though they have these highly paid, you know, experts, if you like, and these experts don't work together. They are too much in their own ego, and that doesn't work. So there's something about leadership in there. What did you learn about leadership of a team of people who are good at what they do?
Yeah, I think the best leaders lead by example. I think that you can tell everybody what to do all you want, but they're not going to do it unless they see someone who they respect and who they want to emulate doing the same thing. I generally think the best leaders are the hardest workers on a team. They're pulling everybody along. They lead with positivity, positive energy, not necessarily putting people down or um, I think that a really good leader has an ego that's fairly reined in, which can be hard, particularly in athletics. But it's easier to get people to listen to you and follow you when you're putting the team above yourself.
And
Um,
how does that work in law practice?
That's a great question. Well, I mean, I think by the same token, if you're the leader, if you're the managing partner of a law firm, then it's important to be present and be seen. And a lot of it seems like kind of the culture of the firm will flow through whoever that managing partner is. And so, being, the hardest working guy, or however you want to look at it, being the person who shows up every day, and is motivated to serve their clients well. And, that all should trickle down to everybody else.
It's
And
very
by the
important. And it's becoming more important in medicine. And when you doing what you do in malpractice, you can see it in medicine. Medicine's now a team sport. It used to be an individual sport, and everybody else had to follow you. And then probably around the 70s, it began to switch into a team sport. And you'll see it now in malpractice, where you have a leader, but it depends on all those other bits, including the institution. So, from a lawyer's point of view, you're not just looking at well, how one person did or did not succeed or had their duty of care and fell in the breach, but it's the fact that others did it as well, and it becomes a combined argument. Has that influenced the way you're taking malpractice claims as opposed to against an individual, looking at institutions, looking at other ways in which care fell down?
Yeah, I think that's a really astute observation, Professor Peyton. I think that it's not something that comes up in every case, but there are cases I can think of where, when you're trying to pinpoint exactly what went wrong, it's not always necessarily one individual who made a mistake, but it's something that we'd refer to as a systems failure. So
Mm,
there were not systems in place that, for example, um, resulted in the right or the requisite information being recorded, which then obviously is relayed to a provider and who is relying on that information in their medical decision making process. And so it might not necessarily be the provider's fault that they made the quote unquote wrong decision. They just didn't have the information at their disposal to make the correct decision. And then backing that up to when the information would have or should have been obtained, maybe it's not the recorder's fault for not asking for the information. It's a systems error in that they were never instructed to ask for that information. So it's really the combination of efforts or the lack thereof that can sometimes produce a really bad result for a patient. And it's because they haven't put the proper system in place to make sure that you get to the right outcome.
yeah, and I think that's an important thought. And law be a bit like medicine. Medicine was more practical 50 years ago. It now is more academic, and medicine, the knowledge in medicine is doubling about every 18 months at the moment, just the sheer volume of it. I remember training, and there was a book called Farquharson, and it had 750 pages of all you ever needed to know about surgery. And you just had to learn that. You got a stamp in your head, and there you were in attending. Now there's that amount of information on the nostrils. So, there's so much knowledge based, cognitive based, that the practicalities are missing. Now, if we take that into the law obviously becoming more complex, more nuanced, and we're bringing in people who maybe don't have your experience of sport. They're more, knowledge based. We call them bookworms, and some of them can be very good at reading the papers. Um, but then they're left with this knowledge base, which isn't put into practical sort of thing. So now you were very, very, high in your knowledge stuff. You got a lot of awards in law on your way through. How did you switch this into the practicalities of the courtroom? What helped you and what would help others to take this knowledge base and get that practical experience?
Yeah, I think that the short answer is my clerkship
Hmm.
on the Southern or with the Southern District of Indiana. So I would encourage any law student or someone who may be early in their legal career, if you're interested in litigation, to try to get some experience working for a judge. And that doesn't necessarily have to be a full-time, postgraduate clerkship. I also externed for one of the justices of the Indiana Supreme Court while I was in law school. And I know a lot of people extern for judges, whether it be a state trial court or a federal trial court or a federal magistrate. There are lots of opportunities to work in a judicial chamber. And I really think that's one of the best, if not the best way for a young lawyer to learn some of those practical aspects of the practice of law. Not only will you be able to observe lawyers live in a courtroom, but you'll also be able to discuss with the judge about what that judge found to be effective advocacy or ineffective advocacy, where the lawyer fell short and where the lawyer did well. And getting that insight, that behind the scenes insight, is something that you can really take and adapt and incorporate into your practice right off the bat. So yeah, I think working for a judge is probably the best way. Otherwise, most of the practical aspects of lawyering, you just have to learn through experience and hopefully having a good mentor that's watching over you.
I mean, a wise man learns from his mistakes, but a genius learns from the mistakes of others. And what you're explaining is that you can see what other people have done and don't do it. Can you give me just, and not an example as such, but what did you learn from seeing how cases did not succeed? And maybe you chatted with the judge. He said, "Oh my Lord, it came in here, it looked one way, now it's another way." What mistakes did you see that you definitely try not to make?
Yeah, so that's a great question. And I think, and maybe this seems obvious to some people, but what I learned in practice is that it's not always this simple, but being candid about your mistakes and owning up to a mistake before the court is always the best way to go. Lawyers sometimes, when things go wrong, they may try to make excuses or shift blame or try to divert attention to other issues, when all the judge wants to hear is you put your hand up and say, Your Honor, I apologize, I didn't calendar this correctly, or we tried to file it and something must have gone wrong with our filing, on the software side or the technological side. And being candid with courts, most judges have probably made that mistake before at some point in their practice, so they'll understand. And if not the same mistake, they will have made a mistake that is similar in nature, enough that they'll be understanding about it. But if you're not forthright about what happened, and if you try to shift blame or divert attention, that's where you can really lose credibility with the court.
Well, of
And
course, that's what lawyers try to do with experts, isn't it? They try to damage their credibility and instead of an expert saying, "I didn't consider that," or "I missed that," and say, "So now what do you think?" Trying to push through it, which is really the triumph of ego over experience, isn't it? I mean, your ego is taking off there, whether it's the lawyer or whether it's the expert. You got to watch the ego and stay with the facts and what you're saying. And if things change, you've got to change with it.
right, that's absolutely right. I mean, there's a saying, in the law, and maybe this is specific to litigation, but you can't write the facts. The facts are what they are. So you have to take them as they're presented in each individual case and just work with them. And if the facts change, as you said, then sometimes your theory has to change, your stance in the case has to change. And sometimes, in the plaintiff's practice where we think we might have a really good case, we might learn facts through the discovery process that turns out it's not so good of a case. And so you also have to know when it's time to be honest with the client and have that conversation and say, look, I don't think that we can continue here, given this new information that came to light.
So that's important about managing client expectation. Now, people walk into the door, and you know, and I know that 80% of complaints are just that, complaints. They're not duty, breach, damage, and consequence. They don't hit the legal aspect of negligence. We use the word negligence freely. I think you were negligent, but there's a legal definition for negligence. And how do you handle people when they arrive knowing that 8 out of 10, they are complaints, they're not happy, they genuinely are not happy, they genuinely believe what they believe, but they do not have a lawsuit because it doesn't reach negligence as such, make a complaint. So when they first come in, how do you handle people that walk in over your door knowing that the majority won't run?
Well, I think the first thing that I try to explain when I know I'm about to have a difficult conversation is that as a client's attorney, my job is never to tell them what it is that they want to hear. My job is to tell them the truth. And if I am doing the former as opposed to the latter, then I'm doing the client a disservice. So, you know, as you've mentioned, Professor Peyton, a medical malpractice lawsuit is oftentimes very complex and there are a lot of layers, and you have to meet each element to prove your claim. So I try to explain to clients that number one, our interests are completely aligned. If I thought there was a way that I could help you and obtain a recovery for you, I would do it. I don't want to turn your case away. That's the least favorite part of my job. But as your counselor and as someone who my job is to tell you the truth and evaluate the merits of your case based on the facts and the evidence, I part of my job is to tell you when I don't think we can proceed and obtain a recovery. And I want to help everyone that comes to me with a complaint. I wish that I could do that. Obviously, that's not practical, and that's from a business standpoint, it's just impossible. And we are running a business, and sometimes if you try to help everybody, you end up not helping anybody. So being selective and being honest with clients is quite possibly the most important part of running a successful plaintiff's practice, particularly if you're focusing on medical malpractice.
It is. It's not overly sympathizing. Understanding people, listening to them, telling them the art of the possible in as good a way as possible right up front in that very first meeting that you're having with them, and that you listen to what they're at, that you will try to help, but you can guarantee nothing at that stage until the facts are clear and how they might fit into what is a legal practice. And I get the distinct impression that's a lot of stuff you do. Did you get that from your dad? Did you hear him talk about that?
Well, my dad did tell me at one point something that really stuck out to me as he said that, one of the ways that you would value or assess the value of a plaintiff's practice is not based on the cases that you sign up, it's based on the cases that you turn away. And I did not understand that when he told me that. But as I have gotten more into my practice, I really do see what he's talking about. Um, being selective and picking the right cases to move forward on is, as I said before, possibly the most important part of what we do. And sometimes you have to make really hard decisions where you have someone who something really bad happened to them or to a family member, and you would like nothing more than to try to help them out and obtain some justice for them. But if you don't think that you can do that, then you're just doing the client a total disservice to move forward. And unfortunately, I've seen and experienced what it's like to take a medical malpractice case to trial and lose. And I've seen the look on the clients' faces, and I know what it's like to invest all of that time and money and emotional energy into a process that takes years and years and years to come to a resolution. And to go all that way and fall short and have a jury tell you no, it is not something that you ever want anyone to experience. So if you don't think that you can take a case to trial and win, you shouldn't be filing that case at all.
Isn't that right? And so that really takes you right back to the beginning, isn't it? As you rightly said, there's a lot of time, effort, and money if you don't sort it day one. You want to do that quickly. You don't want to be waiting months to years to get reports to find you don't have a case even from the report, or that you need different experts. You have a number of experts. So that very initial phase is important. And you talked a bit about technology. You were talking about, booking. How do you think AI is going to influence all of this?
Well, I think AI it's a tool. That's the way to think about it. It's a tool to supplement our practice and to make us more efficient and better at what we do. One thing that is really interesting about the plaintiff's practice, as opposed to all the other areas of law, is our fee structure is a contingent fee agreement, meaning it is contingent upon obtaining a recovery. If we do not obtain a recovery for the client, then we don't get paid. And then by the same token, when we do obtain a recovery, our fee is a fixed percentage of the recovery, regardless of how much time we spent on it. I bring that up to show that where we can make our practice more efficient, that is obviously a great thing because the less time that we have to spend on cases, the more value we're creating. And the issue that comes up though is you cannot use this tool of AI as though it is a magic wand that you can wave at a case and say, okay, let me put some information in here, and whatever this gives back to me, I will go and move forward on it without really putting much independent thought or effort into it. In our effort to become more efficient, we can't be irresponsible. You have to use this tool of AI as a tool, something that is supposed to help you, but it's not the end all be all. Anytime,
Absolutely.
go ahead, Professor.
Absolutely. You've got, I mean, AI doesn't take away your decision making. It's like, well, you can use Google or anything else, or read a book, read a law case, that is very rarely on all fours, but it's pretty close. You still can't say, well, this is the same as that case, so I'll run it the same way. You've got to take that case, you've got to take whatever you get, and that's where the human comes into it, human in the loop, it's called. You, an assistant like any assistant in your practice to give you the chance of using it. And I think there's a brilliant point that you need to do that. You cannot just say, well, AI says this, so it is. It isn't. AI is giving you a perspective. And you can alter it by sticking something else in it, and say, here's more evidence, here's more evidence. And like anything else, it can change the perspective depending on how you choose to look at it. But your job as a lawyer, my job as an expert, is to take that on board as a piece of evidence or an idea of what it might look like, and then to make decisions. Value, risk. That's what we're playing with all the time, isn't it? So anything
Yeah.
that can help is the thing. So, I mean, young people now are coming through with AI, and I think using it ethically and responsibly, as you said, is the thing that you must do. You must do it, and it can't be any other way. Um, so, yeah, it's interesting. It's going to be very interesting to see how it comes behind. Now, what do you do about teaching and training? I mean, obviously yourself, you're growing and developing in your CPD, but What do you do? Do you bring in young lawyers behind you? Do you talk to universities? What do you do as a teacher, a tutor, and a mentor to others?
Professor, I am always very open to talking to other young lawyers or law students if they want my advice or want to learn about my practice. I've had a few students reach out to me from my alma mater at Indiana University down in Bloomington, and there's also an Indiana University Law School here in Indianapolis as well. And I've talked to students at both schools. Um, but it feels like it's been a little few and far between that people have reached out to me to talk. So I can't say that I've done it too often at this point. And being that we're a small law firm, I'm the youngest and the newest lawyer here. So I guess the answer to your question is that while I'm very willing and open to talking to young lawyers frankly, I would say eager to talk to young lawyers about my experience and to help impart, whatever little wisdom I have onto them. I guess I just haven't had as much of an opportunity yet as I would like to.
And what do you find they've asked you, the ones that have come, what what advice are they looking for? They just want to knock around and see and knock off at 4 o'clock in the afternoon and go home? Or the ones that actually ask for your help, what are they looking for?
Yeah, no, I don't think that I certainly don't think that they're kind of just going through the motions. The students that I've talked to have been very genuine and curious in learning about my practice. And, it can be hard to know what area of the law to go into. There's a lot that you can do with a law degree. And frankly, it can be a little bit overwhelming. And, some students come into law school and they have a discrete focus as far as what they want to do with their degree. But I think the vast majority of law students have almost no idea. They know that they're interested in the law, that they want to be a lawyer, but they just don't know what they want to do with it. So I think that's totally normal, and I as hard as it can be and as unnatural it can be, embracing that uncertainty can be very helpful, and just having an open mind. And so the students that I've talked to, they're just kind of curious as to what I do and what does it mean to be a plaintiff's medical malpractice lawyer? What does that mean on a day-to-day basis? When I come to work in the morning, what do I do to fill up my morning? And what are the big picture projects that I work on? And what are the little sort of nitty-gritty day-to-day tasks that I work on? And then I think the second part would just be building a network, which we all, as much, some people like it and some people hate it. Most fall somewhere in between, but we all kind of have to do that to some extent. And so, law students that I've talked to have just been looking to kind of build a network and feel out if there's any, employment opportunities with our firm or anyone that I might know and things like that.
Isn't that so important? And in fact, it's the minority that do that. And when you go there, it's those people who drive to move forward, who look outside their degree, to look at the real practicalities of life, like you did working with your judge in the district court system, where you got to see other things. Now, that defines you, and it tells an employer about you and your way of looking at things, and that you're prepared to put yourself out. Oh, I only work this. I mean, and yet a lot of them come out and think they're entitled. I should be able to get a job. Say, well, what have you done to earn it? What value have you given to somebody else? I find in young doctors, what value have you added? None. You want all the time. Whereas you're clearly pointing out you are influenced. You did it yourself, and you're influenced by others who come to you, and you're so willing to help them if they ask.
Yeah.
And so one of the lessons is if you want to have a successful career, get out there, get into the world and ask
Yeah.
because people are prepared to help if you put yourself forward like you
Right.
did. Um, and you can see where you're going and why you're making a success of what you do. There you were, top of your class in a lot of ways, but you still went outside to find other things. The academia wasn't enough. Um, and I think you're pointing out quite clearly two things. One is your duty to them if they ask to help, and their duty to ask in the first place. So I think that's a brilliant lesson for young people coming through. Just because you're in uni, just because you're doing a degree, get your ego out of this and go and learn other things, the practicalities. Because unfortunately, a lot of those teaching in university settings are not the best in the court. They're full of theory, but not the best. Some are, but I have to say, numbers I've come across wouldn't be the best advocating for anybody. They would just,
Yeah.
do the law. So what a great message. Reese, it's been brilliant speaking to you tonight. I just find that your move towards this has been refreshing. You've shown how your leadership in sport and how you like the team sport, how you translated that into your practice, how you went and weren't just happy with your high marks and your grades, but you wanted that practical experience and you went and got it. You've talked to us about AI, and you know it's coming, and I know it's coming, but it has to be ethically and responsibly, and it will not replace anybody. It is a tool, as you rightly point out, a tool which you've got to learn how to use, like a hammer. If you don't know how to chisel properly, it's going to make a mess. I was recently up in Machu Picchu in Peru, and when you looked at what they did in the 12 and 1300s, to put those stones on top of each other without any cement and get them to sit properly and hold properly over centuries with a hammer. But they had to learn how to use the hammer. That's the big thing.
Yeah.
Reese, thank you so much. I've appreciated this talk so much, and thank you for today.
Thank you, Professor Peyton. I've really enjoyed it as well. It was great to meet you and speak with you.